Good morning. Good morning. I'd like to call this meeting to order for the Judiciary Committee for Tuesday, March 24th, 2026. We are going to be in recess for caucuses, and we will be back shortly. Thank you.
All right. We would like to call back to order the Judiciary Committee meeting for Tuesday, March 24th, 2026. As promised, we have another robust and fun-filled agenda for you all today. So let's get to it. I will entertain. We'll start on number 1, bills for review. I'll entertain a motion to JFS Senate Bill number 259. The JFS is LCO number 3508.
So moved.
Second.
Motion from Senator Kissel, second from Senator Winfield. Is there discussion on this bill? This is one I believe has been before us several years in a row. Let's hope this is the last time it's before us, and then we can actually get it done. Representative Fishbein, maybe a motion, please.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion we create a consent calendar, that we move item number 1, SB 259, an act concerning female genital mutilation to said consent calendar.
Without objection, that's so ordered. Number 2, Senate Bill number 296, an act concerning recommendations from the Department of Consumer Protection with respect to the Connecticut Unfair Trade Practices Act and sports wagering. The motion is a JF.
Second.
Motion from Senator Kissel, second from Senator Winfield. Discussion on this bill. Representative Howard.
Thank you, Mr. Chairman. Sorry, just confirming, this one's still LCO 2149, right?
2149, it's the version we heard in committee.
So-
We heard at public hearing.
Yes, correct. So the issue that I raised concern of then, I still am concerned about. So as I read the language, and as the members of the committee know, I represent one of the 2 tribal casinos. And if I were to place a bet on Providence College to win a basketball game, and then drive from my house in Stonington to Providence, grab a basketball player coming out, pay him money to throw the game, and then he throws the game, the 2 actions that are contemplated here both happen in Providence. So my casino would be out the money on that bet, but I don't see how we could prosecute it.
Well, is that a question?
Sure.
Well, considering those actions both took place in Rhode Island, I would think Rhode Island would have to prosecute it.
Do we know if Rhode Island has this law?
I do not.
So I raised this in public hearing and communicated with DCP in an email from them on March 6th that acknowledged the problem and said we're going to submit substitute language to add language to the effect when such wager or such event occurs in this state. That, I think, would alleviate the problem and make it so that our state could prosecute that crime when our businesses, one of the casino specifically, which is a major tax contributor, was victimized. And I think this language doesn't do that. The S language is not there, and for that reason,
Are you offering an amendment?
Nope, I'm just telling you why I'm voting no. That's why I'm voting no. Thank you, Mr. Chairman.
Mr. Chair,
Senator Winfield.
I would just say that I respect Representative Howard's position here. DCP did reach out, and we haven't yet finished the conversation with DCP, so making sure Representative Howard knows that there has been an attempt to have a conversation with the committee. Thank you, Mr. Chairman.
Further discussion or comment on this? Senator Kissel.
Thank you very much, Chairman Staffstrom. What I'll say is that having worked in the past with the current Commissioner Caffarelli and his staff in various capacities, I will make a representation to Representative Howard that as this is a Senate bill, I will do everything I can to remedy the issue that he raises through working with the Department of Consumer Protection. And it is my commitment that I will not support it going out of the Senate in its current form, and we will make sure that it addresses those concerns.
Senator Kissel, we're actually going to pass this bill temporarily. Let's move on to Senate Bill number 400, item number 3 on our agenda, Senate Bill 400. An act concerning probate court operations. I'll entertain a motion for a JF.
So moved.
Motion is from Senator Winfield, second is from Senator Kissel. Representative Fishbein, please.
Mr. Chairman, trying to get this bill out, there appears to be problems with, in particular, Section 6, and it's the bracketed language C that is removed from the bill in its entirety. I think, at least for the purposes of committee, if we could modify the adjustment that's shown in lines 175 through 187 to reflect an insertion of the following language, and I do have a hard copy that I'll give to LCO once I'm done, that would say the probate court administrator shall annually transfer to each probate court the amount budgeted under subsection B of this section for a probate court's office budget. The remainder of the removal of C that starts at line 177 through 187 would still be a removal. In effect, as I compare the two, all we are doing here actually is leaving the first sentence of C, which makes this a lot easier. The removal would merely be on line 177 through 187, the removal that's reflected in the bill that's before us, restoring the first sentence. So, assuming that one can follow that, I so move.
All right, so there is a motion to amend Section 6 of Senate Bill number 400. I think the representative tried to explain it. He also has a written copy of it that he will hand to LCO after we get done here. So I think the motion is for the amendment that was explained and as written, and allowing LCO to make technical changes that are necessary to implement that. Is that the motion?
That's the motion, and Mr. Chairman, is the motion before the body to JF or JFS?
I believe it was a JF of the bill.
Okay.
All right, let me start over. I think we got a little laywayed with the previous bill. So we've moved on to Senate Bill number 400. The motion, LCO, was there a JFS that was prepared on this already? Or was that the previous bill?
Yes, Representative Staffstrom, there was a JFS previously prepared. I am aware of the language that Representative Fishbein is about to offer. I have prepared a new version of the substitute that would include that language. So if you wanted to pass this matter temporarily, then everyone could have that language.
Let's do that. Let's do that as well. Let's pass item number 3, and we will wait for the updated JFS language on that bill as well. All right, moving along, but not making progress. All right, let's try to actually vote on something. How about item number 4? Senate Bill number 476, an act concerning visitation policies of the Department of Correction and the transfer of funds held in trust by the Department of Correction to persons who were formerly incarcerated. This motion will be a JFS. The LCO number is 3577. I have a motion from Senator Winfield and a second from Senator Flexer. Senator Winfield, would you like to explain the bill?
Thank you, Mr. Chair. This is the bill that came before the committee that provided for the 3 in-person visits per week and dealt with those funds that are mentioned in the title, and also on a visit it prohibited the use of voice communication and other communication services to sit in the place of those in-person visits. It deals with an important issue in our prison system, and I would urge this committee to adopt it.
All right, Senator Kissel.
Thank you very much, Chairman Staffstrom. Well, fundamentally, I support the concepts in this bill, and indeed, I want to thank Attorney Dykes of our staff. After the auditor's report, one of the things that was found lacking was a more streamlined and effective way to get money back to inmates that are released from the Department of Corrections. And I think this bill makes strides in that direction. The area of concern to me, though, it has to do with the 3 visits per week. And as a matter of policy, I totally support that. I have said over and over and over, 90% of the inmates are going to be released back into society. Visits with loved ones, friends, family is extremely important to those that are incarcerated, and it should be supported and encouraged. But as folks on this committee are well aware, I have more correctional facilities in my Senate district than any other senator in our legislature. And we had testimony from folks from Local 391, the Corrections Officers Union that serve in my neck of the woods. And they said that at this time, they feel that they are drastically understaffed. And that the Department of Corrections is having a difficult time filling posts that are already ascribed as being necessary. And if that is not addressed in a timely fashion, that we will continue in this spiral of individuals being pressed into overtime service, double shifts, and it goes round and round and round, and it's burning people out, but well before they reach the age of retirement. So it's a vicious cycle. It needs to be addressed, and what they brought to our attention was that this policy of the increased visits would demand even more personnel time to address. And so they said, what are you doing to us? We don't necessarily have a problem with the policy change, but we're already understaffed. And so it's my understanding that some folks in the union have reached out to us. I have to go back and see if I've received any communications via email regarding that aspect of the issue. It may already be addressed in the S language. I'm not so sure of that. So at this time, I just have to vote no to flag this bill to make sure that to the extent that issue is still unresolved, that I do my best to try to fix it before this bill hopefully crosses the finish line. Thank you, Mr. Chair.
Further questions or comments on this bill? Further questions or comments? If not, Madam Administrator, if you could please call the roll.
Roll call vote on Senate Bill 476 to JFS it to the floor with LCO 3577. Winfield.
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer.
Yes.
Gadkar Wilcox.
Yes.
Pazino. Kissel.
No.
Fishbein.
No.
Blumenthal. Brown. Cabrera. Callahan.
No.
Ciccarella. No. DiCaprio. Delaney.
Delaney, yes.
Dillon. Doucette.
Yes.
Dubitsky.
No.
Elliott. Gaston. Gilchrist.
Gilchrist votes yes.
Godfrey. Howard. Jacobson.
Jacobson, yes.
Johnson.
Representative Johnson votes yes.
Khan. Lamarck Muir.
Yes.
Lesser. Lesser.
Lester, yeah.
Marr.
Senator Marr votes yes.
Miller. O'Day.
O'Day votes no.
Osborne.
Osborne votes yes.
Pavlik Tomato.
Pavlik Tomato votes no.
Perillo? Quinn?
Yes.
Ramen? Roberts?
Yes.
Rutigliano? Sims?
Sims in the affirmative.
Veach?
No.
Walker? Wilson?
Thank you, Madam Secretary. We will hold the votes until 3 o'clock. All right, number 5, Senate Bill number 484, an act concerning distracted driving and the safe operation of a motor vehicle in a highway work zone. The motion will be a JF.
So moved.
Everybody wants to move it. I'm going to go with Senator Flexer on the motion, second from Senator Kissel. Discussion on this bill. Is there discussion? If not, do we need a roll call on this?
Which one is this? Number,
DOT bill? Roll call?
number 5? Yes, roll call.
Roll
Yes.
call vote, please.
A roll call vote on Senate Bill 484 to JF it to the floor. Winfield?
Winfield in the affirmative.
Staffstrom?
Yes.
Flexer?
Yes.
Gadkar Wilcox?
Yes.
Fazino? Kissel?
Yes.
Fishbein? Blumenthal? Brown? Cabrera? Callahan?
Yes.
Chicarella? DiCaprio? Delaney?
Delaney, yes.
Dillon? Doucette? Dubitsky?
No.
Elliott? Gaston? Gilchrist?
Gilchrist votes yes.
Godfrey? Howard?
Yes.
Jacobson?
Jacobson, yes.
Johnson?
Representative Johnson votes yes.
Khan? Lamarck Muir?
Yes.
Lesser?
Lesser,
Senator Lesser, if you, again, what's your vote?
Lesser, yes.
Thank you. Marr?
Senator Marr votes yes.
Miller? O'Day? Osborne?
I'm sorry.
Representative
O'Day votes no. Yes. Sorry. Yes.
O'Day, I'm putting down for yes, and Representative Osborne?
Osborne votes yes.
Thank you. Pavlik Tomato?
Pavlik Tomato votes yes.
Perillo? Yes. Quinn?
Yes.
Ramen? Roberts?
Zaman votes
yes.
So we have another 7.
Roberts?
Minutes. Yeah.
Thank you. Rutigliano? Yes. Sims?
Sims in the affirmative.
Veach?
Yes.
Walker? Wilson? Dillon?
Thank you. Number 6, Senate Bill number 5.
Gaston votes yes. Thank you.
Folks, we'll get to votes at the end if we missed you. Senate Bill number 503, an act concerning sentencing and the parole eligibility for individual. Oh, sorry. We're going to go to number 6, which is Senate Bill number 502, an act concerning discretionary transfer from juvenile court to adult court. The motion will be a JF.
Second.
Motion from Senator Kissel, second from Senator Flexer. Discussion on this bill. Senator Kissel.
Thank you very much, Chairman Staffstrom. It's my understanding that what this bill will do fundamentally is allow us to benchmark and keep track of these potential transfers because we get stories about judges denying this and then we're not sure if that's really true, and judges are less likely to come forward and offer piecemeal evidence regarding their determination. So I think this would be a good way to just get some data that we can act upon down the road, and I happily support the bill. Thank you, Mr. Chair.
Thank you. Further discussion on this? If not, Representative Fishbein.
Mr. Chair, I make a motion to move item number 6, SB 502, an act concerning discretionary transfer from juvenile court to adult court to the consent calendar.
Any objection to placing the item on consent? Any objection? Seeing none, order to go on consent. All right, number 7, Senate Bill number 503, an act concerning sentencing of and parole eligibility for individuals whose offenses are committed when such individual was under the age of 26 years old. The motion is a JF.
So moved.
Second.
Motion from Senator Flexer, second from Senator Winfield. Senator Winfield.
Thank you, Mr. Chair. And this bill is something that's been before this committee in the past. We've dealt with this issue for the last decade or so. The difference here is that those who would get the opportunity under the provisions of the law would be those who are under the age of 26. And so that's really where the operational question here is, and whether folks think the age of 26 is appropriate or too far. Age of 26, from the perspective of those who are advocates for this bill, falls in line with the science that we have talked about for a long time, the science we talked about yesterday, and the ability of young folks to do higher order executive function thinking in emergent situations. Mr. Chair, I'm supportive and would urge the members of the committee to vote in favor of this bill.
Further discussion, Senator Kissel.
God bless you, whoever sneezed out there. Thank you, Chairman Staffstrom. I'm going to be voting no today, but that doesn't mean I'm necessarily going to be a no when it ultimately reaches the Senate. I've sat through the entire hearing on this issue for the past several years. Actually, as Chairman Staffstrom said, this and Chairman Winfield, this notion, the scientific notion that brain development isn't really done, especially in males, until around 25, 26. As I stated during the public hearing, I've been hearing this for probably close to 20 years. I remember one of the first public hearings we had where we had via, I don't think it was Zoom at the time, it was some sort of pre-Zoom visible conference from a professor at Dartmouth who basically compared how people react to certain emergency situations. And they took younger people and said, would you jump into a pool of sharks? To those that were over 26 years old, probably close to 100% said, no, absolutely not. To those younger, amazingly, responses like, well, I don't know, are they hungry? I think I'm feeling good today. Maybe I can outswim them. It was amazing how they would not consider the high risk of jumping into a small pool of sharks. So that one was a really good demonstration that this is real. And as Chairman Winfield has stated, that this is how the brain responds in particular to moments where adrenaline is high and fast reactions are necessary. And what does that usually translate to? An outpouring of violent behavior, gang violence, street violence, things like that. I'm sympathetic to the fact that during the public hearing, lots of people testify that they turned their lives around while they were in prison. They were doing long bids. They had fundamentally committed very serious crimes. The people I didn't hear from that day were the deceased, the dead victims, members of their family, people that have no ability to come and testify because they're gone. So there's two sides to this issue, and I want to make sure that I study both sides. And yeah, people turn their lives around. I get it. I encourage that, or I support that. But there's a reason why people get long bids in the first place, long sentences. It's because either a judge or through a plea agreement or a jury have adjudged that they've committed a very serious offense. And at the sentencing, all the information is brought before the judge. The things that weigh in the defendant's favor, how they were raised, violent backgrounds, gang affiliation, things like that. And then the sentence is handed down. it's very hard 20 or 30 years down the road of a 40 or 50-year bid not to look at things differently. And I don't consider myself a hard-hearted person, but it's a difficult balance that we're going to have to draw if we're going to change everything midstream. And so I'm not ready to do that at this time, but I'm open to the notion that we want to encourage people to turn their lives around while acknowledging they will be released back into society. And ultimately, what we want is hardworking, law-abiding, tax-paying citizens that are a benefit to their community, not an individual that has no future and sees nothing left for themselves but going back to a life of crime. But at this time, I'll be voting no. Thank you, Mr. Chair.
Thank you. Representative Howard, Representative Howard, okay.
Thank you, Mr. Chairman. Just a couple of quick points I want to make. One, I just want to say for the Senate chair that, or whoever's proposing or advocating for the bill, that the removal of the arbitrary date in October of 2005, I think it is something I support. I understand how it got there. I actually learned the history about that, and I support removing that, the October 1st, 2005 date. Going from 21 to 26, again, I have mixed feelings about, but I have a question about the bill, though. If I could, through you to the Senate chair.
Please proceed.
Okay. Sorry, I lost my space. Line 262. In line 262, it says there shall be a rebuttable presumption that any person who is made eligible for parole pursuant to Section 1 that such person has satisfied all other factors concerning such person's parole eligibility. Who would rebut a presumption at a parole hearing?
Senator Winfield? Do you want your question rephrased?
Yeah.
Representative Howard, if you could just rephrase the question.
Yeah, and partly it may be because I'm just not as familiar with parole hearings, but in the criminal court, when there's a rebuttable presumption, for example, we've discussed this around cash bail, and that's not before us today, but that, for certain offenses, for example, there would be a rebuttable presumption of release. And the rebutter, if that's a word, would be the state in that case. Who would rebut this presumption in a parole hearing?
Representative Howard, I believe even at a parole hearing, certainly a victim's family is notified of the parole opportunity. I believe the state's attorney's office is also notified. So there could be other testimony that's presented beyond that, just of the individual who is seeking parole.
All right, thank you. And again, I just wasn't all that, I've never sat through parole hearings, so. All right, that part is satisfied, thank you. And the other question then is, so if the individual, as the bill's written, was convicted of a crime and sentenced, and at the time they were under 26, we're making a presumption that they've satisfied all other factors concerning their eligibility? Is that a good read?
That would be what that section does, yes.
So I'll just say this. I mean, I'm going to be no today as well. Again, I support the date change or the removal of the arbitrary date. I know it's not all that arbitrary, or at least it wasn't at the time, but anyway, it's arbitrary now. And then, the age is something I'm open to more discussion on, and I think I need to kind of dig down on that language there in lines 262 to 266. So whatever my opinion is worth, that's where I'm at. I'm a no. Thank you.
Thank you. Representative Fishbein?
Thank you, Mr. Chairman. Personally, I think that over the last 10 years, our criminal justice system in Connecticut has changed. Thanks to many of the advocates that are here as representatives, as well as the advocates that are here listening today, we are different. I see some very heinous cases. And when I say heinous, I'm not talking about from the victim side. I'm talking about, in my opinion, abuse of the criminal justice system 25 years ago, 20 years ago. And that's why I was part of the date change that we agreed to, I think it was 3 years ago, to shift that. I think that's important, but we are certainly different. So the language before us here today doesn't give credence to that change in our criminal justice process. It says no matter the changes that you've made, we're still going to open it up. The individuals that would benefit from this, to my knowledge, have created, in the most part, as a result of a death. Individuals that are not eligible for parole. We're opening this up. Ultimately, what we're talking about is people and lives on both sides. We want people to be productive members of society through the process, but we also have to recognize the people that aren't here with us today, that can't speak. As we've had those changes over the last 10 years or so, we reflect, I reflect, where are we today? Just yesterday, the Connecticut Violence Prevention Group, this is a group, a major, Hartford, New Haven, major groups, put out a report that says that violent crimes by youths may be decreasing, but the kids are getting younger that are doing it. Violent crime. Just last week, like a 13-year-old shot somebody in Hartford. That's where we are. So, public policy-wise, you're sending a message. Should individuals that were convicted last year, convicted of killing someone, were sentenced with no ability to get parole, would be afforded an opportunity by this bill to bring the victims, the remaining, the family members, back through the process, even though they were just sentenced. That's not a public policy that I foster. I want people to succeed. But this does not get us anywhere. I understand that there's a want for sympathy for those individuals that, for whatever reason, killed someone. But I think at some point, this state has to stand up for victims. So, thank you, Mr. Chairman.
Representative O'Day.
Thank you very much, Mr. Chair. We've got, and I do respect and deeply the good chair's comments on, and some of the comments made yesterday about how we're talking about a decision that's instantaneous, that they don't have time to think about, versus, you have a long time to think about something, and your deliberative process may be better than your instantaneous thought process. And I hear it, and I respect it, and I understand it. But looking at what we have people under 26 doing, they're serving the military at age 18, and they have to make an instantaneous decision whether to shoot somebody and kill them. We have, at age 23, Coast Guard captains in captaining a patrol boat at age 23. We've got squad leaders leading men in between 9 men or women to 150 under 25 or 25 and under, leading squads of people into battle. That there's no more instantaneous important decision to be made. So, I hear and respect and understand the desire here, but unless we're willing to change our laws and a lot of other things, I just don't think we should be increasing it, all the way through here. I'm looking at lines 191, going from 21 to 26 and throughout. Um, I can't support it. And we are certainly allowing uh, minors to make decisions in transitioning and doing things to their body in a permanent nature. Now, granted, I understand that's a more deliberative process maybe than what some of these people face in an emergency, but we've got military people younger than what we're proposing here making life and death decisions for hundreds, if not thousands of people. So um, I'm a no on this, and I appreciate the time, Mr. Chair.
Representative Sims?
Thank you, Mr. Chair. I kind of agree with my Republican colleagues on this issue. As you all may know, I had a brother who was killed on Christmas Eve of 2007 because he asked two young men who were smoking PCP in front of my mother's house, and it was coming through the windows. I had all my family up from Florida visiting, and my brother went outside and asked these young men not to smoke in front of my mother's house. One of them decided to pull out a gun and say, "I don't like you, young old man," and they began to tussle for this firearm. Firearm got loose. The other gentleman came out, picked up the gun, and shot my brother and killed him. So for me, I could never vote on a bill that allow an individual to get out of jail because he was 26 years old. Now, it's one thing if you commit a petty crime or you stole something or you sold some drugs or you stole a car, but it's a different story, a different conversation when you take a life. There's no coming back from that. I have two young nephews who are still reeling and dealing with this difficult of growing up without a father. I don't understand how this legislation is helping young men who make these kind of decisions. These are final decisions. So I would like to be a hard no on this because I don't think they should get a second chance when you take someone's life. There's no coming back from this. My family has been devastated for the past decade or so. I would hate to see this young man get out because he was 26 when he shot my brother. But that was a choice that he made. And I don't think this choice should alleviate him from serving his sentence. He was sentenced to life, 60 years to life. I don't think it's fair to my family or to any other family whose loved one was taken from them because a young kid decided to pull that trigger. So for that, Mr. Chair, I'm a hard no, and I encourage my colleagues not to support this bill as is. Thank you.
Thank you, Representative. Representative Drabitsky.
Thank you, Mr. Chairman. Mr. Chairman, the public hearing on this bill went quite long, and the testimonies were very emotional. We had students essentially come in and read the testimony of incarcerated people, inmates. We had some scientists. We had parents and relatives of incarcerated people. We had some former incarcerated people. And almost universally, they told us that a person's brain does not fully develop until they're 26 years old. And frankly, it got to me to the point where I was going to support this bill. I was going to support this bill because it seems like a person's mental capacity to make decisions doesn't fully develop until 26. And then we had yesterday's committee meeting where there was an amendment to prevent 12-year-olds and younger from making life-altering decisions that would be irreversible, that would change for the worse their bodies forever. And I heard backpedaling, I heard dancing through the raindrops, I heard all sorts of explanations and excuses as to why a 12-year-old can make such decisions. And now we're here hearing that a 26-year-old can't. I'm baffled. It doesn't sound like science to me. It sounds like politics to me. And I'd like to stick to the science. I'd like to make decisions based on whether or not a person's brain is, in fact, fully developed. But my colleagues have told me, in words or deeds, that we should ignore that. Until I get some sort of cohesiveness, some sort of statement that we're either going to follow the science or not follow the science, I can't support this bill. Thank you, Mr. Chairman.
Thank you. Representative DiCaprio.
Thank you, Mr. Chair. I'd just like to make a couple statements. I listened to the testimony the other day, the folks that came in to talk about this bill, and truly a tragic, in my opinion, tragic situation and tragedy for, those individuals. But again, you heard the good representative just share from his family experience, from the victim's point of view. I read an article that you may have already talked about it. I've been out on a commitment today where there's multiple individuals on the list that potentially this bill could affect, convicted of murder. And I think I've already heard someone say, the victims can't come back and talk about it. So it's truly a tragedy on both sides of the equation. But certainly I feel like 26-year-old people are adults, and they should be responsible for their actions. Thank you.
Representative Roberts.
Thank you, Mr. Chair. I just want to say some comments. Truly support the conversation today from everybody. I do look at this committee and I see a bunch of attorneys, some law enforcement officers, and I'm always going to embrace that. But I'm also always going to embrace the system. And as a black man, make up 13% of the state. But I overpopulate the prison system. As a Latino man, you make up 13% of the state. You overpopulate the prison system. So there are more of my white counterparts outside of the prison system than my black and brown counterparts. I sat through 189 testimonies remotely and in person. I've read over 300 written testimonies to understand this bill. So it's not a get out of jail free card, because you have to complete 60% of your time. I look back at that and everyone's saying it's a get out of jail free card, but if you get 30 years, you have to complete half of that or more. I also looked at like the fiscal note, because everybody always wants to say it costs money. You guys are paying $62,000 to $180,000 per year per inmate. And the recidivism rate in Connecticut is 11%. We have to make this make sense. So I sat through these testimonies, and if you guys remember, a gentleman got up there and said it all started at a party when we were 16 years old. I'm that 16-year-old that was at that party. I'm that 18-year-old that was in the car with my best friend when he got murdered. I'm also that 21-year-old that lost his best friend, a Caucasian male, who's currently doing 35 years to life. You guys have your kids on your insurance till you're 26 years old. But their brains are fully developed. I respect everybody that's attorneys and law enforcement, but until you can walk in the shoes of the people that are mass incarcerated in the state of Connecticut in your prisons, you truly don't understand that background. It's not about being hard on crime. It's about being smart on justice. Thank you, Mr. Chair.
Thank you, sir. Further questions or comments? Further questions or comments? If not, Senator Winfield for some concluding remarks.
Mr. Chair, I just want to make sure that, to Representative Roberts' point, that we understand how the bill works. This is an eligibility issue. And the eligibility never goes below 12 years of serving a sentence, whether you're serving a long sentence or a shorter sentence. 12 years is the point at which you become eligible. That's for anything under 50 years. It's 12 years as a minimum, or 60% of your sentence. And at 50 years, it starts at 30. So it was suggested that folks could immediately apply and be eligible. That's not correct. And we've passed laws before about eligibility that would preclude folks from immediately trying anyway. When you read the law, not just what we're dealing with here in whole, there will be no folks who can immediately apply for this. But I just want to talk about, differences in experience. I guess I'm going to, as long as I'm on this committee, I'm going to be talking about differences in experience. I came to Connecticut and I was working in the engineering field. When I left, I went out to the streets of New Haven to try to help some of our young folks. I also tried to help some people in my neighborhood by giving people who didn't have employment. And I had this man who was working for me. And, I let him work around the property and do stuff. I would make up jobs just so that I could justify paying them to do those things, and they could have the money to eat and do other things. And one Sunday morning, I hear on my door. And I go to the door and I open the door, and it's one of the guys that's working for me. He's like, "Let me in the house, let me in." I never let them in the house, so I said, "No, we can't do that." And I pushed him out and stepped outside. And he says to me, "You've got to let me in the house. He's going to kill me." And I know who he was talking about. I said, "Who's going to kill you?" And he points down the street, and there's a kid who isn't clearly in his right mind. He's angry. He's hot. And he's got the gun out running down the street. So I tell him to go around the side of the house, and I walk up to the kid. Now, I'm not crazy. I've been doing intervention, so I know how to do this. And eventually, And I pointed out to the kid where he was, whose house he's going to shoot this guy in front of. All the attention is going to come on him. And this angry kid who is thinking very quickly and not fully starts to have the realization dawn on him. And so eventually I asked the guy, and this is how crazy this is. I asked the guy, the kid, well, how much money did he owe you? And he owed him $25. He was going to take his life on my property, which makes this high profile, for $25. But when someone was able to get him to slow down, to think, to function as the executive function of his brain, he made a different decision. That's what this is about. The people pushing this are not folks who don't understand crime, who've never had crime happen to them. I saw bullets in the side of my house. Some of you may have seen the story. They're still there. I understand crime a lot. When I grew up, crime was always visited upon me. It was actually so regular that we didn't even call the police. But these are people who understand how these things happen. And despite the fact that we have crime visited upon us, despite the fact that these things are extremely close, still suggest that people do deserve a chance that does not necessarily end in them being paroled, but ends in them having the opportunity for the circumstances, the reality to be assessed when we think about whether or not they should be. For those reasons, Mr. Chair, I will be supporting this bill. Thank you.
Madam Administrator, please call the roll.
Roll call vote on Senate Bill 503 to JF it to the floor. Winfield,
Winfield in the affirmative.
Staffstrom,
Yes.
Plexer,
Yes.
Gadkar Wilcox,
Yes.
Fazino, Kissel, Fishbein,
No.
Blumenthal, Brown, Cabrera, Callahan,
No.
Ciccarella, DiCaprio,
No.
Delaney, Dillon, Doucette,
Yes.
Dubitsky,
No.
Elliott, Gaston,
Yes.
Gilchrist,
Gilchrist votes yes.
Godfrey, Howard, Jacobson,
Jacobson, yes.
Johnson, Khan, Mark Muir,
Yes.
Lesser, Marr,
Mar votes yes.
Miller, O'Day,
Day votes no.
Osborne, Pavlik D'Amato,
Pavlik D'Amato votes no.
Perillo, Quinn,
Yes.
Rahman, Roberts,
Yes.
Retigliano, Sims,
Sims, no.
Veach,
No.
Walker, Wilson, Delaney,
In the affirmative.
Fazino.
Fazino votes yes.
Thank you.
Number 8, Senate Bill number 509, an act concerning address verification reform for registrants. The motion will be a JFS. It's LCO number 3584.
So moved. Second.
Motion from Senator Kissel, second from Senator Winfield. Discussion on this bill. Discussion on the bill. If not, Madam Administrator, please call the roll.
Sorry, Mr. Chair, I'd raised my hand.
I apologize, Representative O'Day, I didn't see you there. Go ahead.
So, I was looking for the line on 509 where it's changed from a failure to properly register is changed from a D felony to a C misdemeanor. I think it's line 82 and line 54 and 82 and 24. And I'm just wondering, I'll vote for it now to get it out of committee. But I'm hopeful that it'll go back to a D felony And I'm wondering, Mr. Chair, why it was reduced from a D felony to a C misdemeanor.
Senator Whitfield.
Thank you, Mr. Chair. I can say that there are folks who have been working on this bill for a very long time and have, as you know, Representative O'Day, have come in front of us suggesting that the way in which we have been dealing with these issues is untenable, too harsh, and the change in the penalty is a part of that conversation. And I don't know that, I suppose, since it's a Senate bill, the person who, once it leaves the committee, will be dealing with, directly at least, with the changes that are going to happen. What I feel about your desire to leave it as it is, but I am open to having a conversation. I do think that the way that we've been operating feels more protective of folks than it is, and leads to some folks having to deal with the system again when they're making every attempt to do what we're asking them to, and is not smart policy. But Representative, I'd be willing to engage you on in a conversation.
Thank you very much, Mr. Chair. I appreciate the response. Like I said, I will vote for it to get out of committee, and I look forward to talking to you. I appreciate it. Thank you.
Thank you. Further questions or comments on this? If not, Madam Administrator, please call the roll.
A roll call vote on Senate Bill 509 to JFS it to the floor with LCO 3584. Winfield.
Winfield in the affirmative.
Staffstrom.
Yes.
Flexer.
No.
Gadker Wilcox.
Yes.
Fazino.
Fazino, yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown. Cabrera. Callahan.
No.
Chigarella. DiCaprio.
Yeah, DiCaprio, yes.
Delaney.
Delaney, yes.
Dillon. Doucette.
Yes.
Dubitsky.
No.
Elliott. Gaston. Gilchrist.
Yeah.
Godfrey.
We're not ready on the gun bill.
Howard.
We don't have
No.
the language.
Jacobson.
Jacobson, yes.
Johnson. Khan. Lamarck Muir.
Yes.
Lesser.
Lesser, yeah.
Marr.
Mar, yes.
Miller. O'Day.
Yes.
Osborne. Pavlik Tomato.
Pavlik Tomato votes no.
Perillo. Quinn.
Yes.
Rahman. Roberts. Retigliano. Sims.
Sims in the affirmative.
Beach.
No.
Walker. Wilson.
All right, we are going to return to item number 3 on our agenda, which we had previously called, that was Senate Bill number 400. I'm going to entertain a motion for JFS. It'll be LCO number 3542.
So moved.
Motion from Senator Winfield, second from Senator Kissel. Representative Fishbein.
Thank you, Mr. Chairman. Mr. Chairman, I make a motion that we strike sections 5 and 6 from the bill. I just, for the record, there's a concern by some members of my caucus with regard to the apparent overreach by those sections. And I'd like to get the bill out of committee here today with the intent of working on the intent of the division, along with the concerns that have been raised by my caucus. So that's the purpose of the motion.
Second.
So there's an oral amendment to strike sections 5 and 6 from the bill. It was made by Representative Fishbein. It was seconded by Senator Kissel. Is there discussion? Senator Winfield.
Thank you, Mr. Chair. I've been working with Representative Fishbein on this and recognize the issues. I think we agree that there is a way to do this. It just hasn't been done in a way that is currently satisfactory. So I will accept that as a friendly amendment for now. Thank you, Mr. Chair.
Any further discussion on this? If not, let me try your minds. All those in favor of the amendment, please signify by saying aye.
Aye.
Any opposed, nay. The ayes have it. The amendment is adopted. Further on the bill is amended. Further on the bill is amended. If not, Representative Fishbein for motion, please.
Yes, thank you, Mr. Chairman. Mr. Chairman, I make a motion we move item number 3, SB 400, an act concerning probate court operations to the consent calendar.
Any objection to placing the item on consent? Any objection? Seeing none, that's ordered. All right, let's next turn to
Okay, Mr. Chair. We'll go to item number 10, which is House Bill number 5306, an act concerning sentence reduction or relief for survivors of domestic violence, sexual assault, stalking, or human trafficking. The LCO is 3582. Moved by Representative Staffstrom, seconded by Senator Flexer. Is there discussion? Is Mr. Chair?
Thank you, Mr. Chair. Mr. Chair, this, I believe, is a very important bill that looks at the instances or the implications of when someone is a victim of domestic violence, stalking, or human trafficking, and they essentially commit certain offenses as a result of those traumatic events in their life. I think in this state, I don't think it's any secret, I believe we have far too many mandatory minimum sentences. I think mandatory minimums was from a bygone era in which we essentially tied courts' hands to make decisions and enforced them into imposing sentences for certain types of crimes without properly considering all the surrounding circumstances. This bill is an attempt to correct that with respect to certain folks who have been the victims of crime themselves through domestic violence, stalking, or human trafficking. This really has been a collaborative effort. The original language came to us from the great advocacy by the Connecticut Coalition Against Domestic Violence, and I know they've been in extensive conversation since the public hearing with the judicial branch, the Office of the Chief Public Defender, and the DCJ under the leadership of Senator Flexer, in bringing those organizations and groups together to modify the bill and I think make it a stronger bill coming out of committee. I will say I do believe this bill probably needs another round of revisions before it hits the House floor. I think progress has been made as we get towards our JF deadline. I'm not sure that the language in front of us 100% gets us there, but I think this is a very important topic. I think it's actually one of the more important bills we will take up this session, and I hope the members will support it moving forward today as a marker that our criminal justice system should be looking very carefully at instances of domestic violence, stalking, and human trafficking, and what collateral consequences stem from that for folks who then themselves turn around and commit a crime. Thank you, Mr. Chair.
Thank you, Mr. Chair. Other comments on the bill? Other comments on the bill? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5306 to JFS to the floor with LCO 3582. Winfield.
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer.
Yes.
Gadkar Wilcox.
Yes.
Fazino.
Fazino votes yes.
Kissel.
No.
Fishbein.
Yeah. No.
You're no.
Blumenthal. Brown. Cabrera. Callahan.
No.
Chicarella. DiCaprio.
DiCaprio, no.
Delaney.
Delaney, yes.
Dillon. Doucette.
Yes.
Dubitsky.
No.
Elliott. Gaston. Gilchrist.
Gilchrist votes yes.
Godfrey. Howard. Jacobson.
Jacobson, yes.
Johnson.
Representative Johnson votes yes.
Khan. Lamarck Muir.
Yes.
Lesser.
Lesser, yes.
Marr.
Mar, yes.
Miller. O'Day.
O'Day, O'Day votes no.
Osborne. Haddock Tomato.
Pavlik Tomato votes.
Haddock Tomato again. One more time, please.
Pavlik Tomato votes yes.
Thank you. Perillo. Quinn.
Yes.
Rahman. Roberts.
Yes.
Bertigliano. Sims.
Sims in the affirmative.
Beach.
No.
Walker. Wilson. Blumenthal.
Thank you, Madam Administrator. All right, now we'll turn our attention to item number 17 on the agenda, which is House Bill number 5567. There's a JFS for it. It's LCO 3553, and it's an act concerning healthcare in the Department of Corrections. Is there a motion?
So moved.
Moved by Representative Stastrom, seconded by Senator Flexer. Is there discussion? Representative Stastrom.
Thank you, Mr. Chair. Mr. Chair, I don't think it's an overstatement to say the provision of healthcare services within the Department of Correction right now is at a crisis level. Just yesterday, we saw yet another death in our prisons. Every day, this committee hears more and more stories about folks having untenable wait period to get to see a doctor. We hear every day about specialized services not being available to inmates. And probably most concerning, we hear repeated stories about how routine medication is not delivered to individuals on a daily basis. Medication that may be needed to control cholesterol, blood pressure, the type of stuff that many of us take on a daily basis and rely on is not being given. Mr. Chair, I don't need to tell you that almost all of the individuals who cross through the doors of our correctional facilities someday come out the other side. They are passing through. And when healthcare is disrupted because someone is serving a 6-month sentence, a 1-year sentence, maybe they're just in for a few days waiting to post bail on an arrest. It creates long-term health and potentially deadly consequences to an individual who was arrested, sometimes for very minor or short-term sentences. The bill before us, Mr. Chair, I don't profess to say this is going to solve all those problems. It won't. But it is a first attempt at some legislative action to try to provide better oversight, to try to get to the root cause of some of the issues we're seeing, and to respond to, I think, some of the very emotional testimony we heard at the informational session before session started when we met with the Government Oversight Committee. I suspect we'll be back again next session with further on this. I know there's going to be a change in leadership of the Department of Corrections as well that will have to be consulted on this, but we cannot let the session go by without doing anything. And this bill is the attempt at doing something, Mr. Chair. I hope the members will support it.
Thank you, Representative Stasham. Senator Kissel.
Thank you very much, Chairman Winfield, and I appreciate the remarks of Chairman Staffstrom. I've thought long and hard about this bill because in some respects, as stated, it may not be a finished product at this point in time. But again, as the state senator who has more correctional facilities in his or her district than any other state senator, I'm acutely aware of what's going on within our correctional facilities. It is extremely disconcerting and troubling to hear about the deaths of inmates in our correctional facilities. This one that Chairman Staffstrom mentions from just yesterday, this gentleman, I believe, was just in his 40s. You know, when people go in for a short bid, a short number of years, it's not a death sentence. And yet, in the last few years, we've seen a lot of people dying in the Department of Corrections. And it's not because of the pandemic or anything else like that. Troubling. In particular, in my district, there's one area that's under huge amount of stress. The correctional facilities of Cebulski and especially Osborne. In that area of my district, straddling the Enfield-Summers town line, those facilities, for whatever reason, probably just administrative efficiency, are the area where the oldest inmates are housed. So as you work your way through the system, you're graded on your security risk, but also they're moved around from facility to facility, assuming they're appropriately assigned based on security, based on age as well. And that area where they tend to go the older they get is up in my neck of the woods and tend to be either in Summers or on the Summers border. How has that impacted my town of Summers? Well, I've worked with them over the last several decades because their little 2-ambulance town, it's a small town, is now the default ambulance call for the Department of Corrections. You would think the big old Department of Corrections here in the state of Connecticut would have its own ambulance service ready to go for its most senior inmates. It does not. It relies on one of my smaller towns. I have fought over the years to get them appropriate rates for calls, and that was a battle. And I'm sure the town would say it's not enough. But also, those handful of ambulances and volunteers that help with that are for the town. And the state says, well, we're here. And guess what? The town says, well, maybe we won't respond. And guess what? They can't do that. There is a legal as well as moral obligation that if someone at the department, Osborne, calls 911, one of the senior inmates, chest pains, ambulance has to go. And so not only am I seeing this problem that Chairman Staffstrom so articulately pointed out about poor health care being provided to inmates throughout the state of Connecticut, it is exacerbated with the older population, which is now housed within the 7th Senatorial District. On that area up in the corner, the northeast corner of Enfield, straddling over into the quaint, beautiful, bucolic town of Summers. And it's got to change. It's got to change. And so this may not be a finished product, but we've got to move this along because the Department of Corrections, I hate to say it, but I'm just going to say it, it's got to get its act together. I've been watching this department over the years, and it's not at its best right now. It's poorly staffed. It doesn't seem to have a rudder. And the health care provision, which has been an issue ever since Commissioner Semple was in charge, has not gotten better with time. So please, Department of Corrections, take care of your most senior inmates, address these endemic issues, and I would hope my colleagues would move this bill along. Thank you, Mr. Chair.
Thank you. Representative Howard, followed by Representative Fishbein.
Does he want to go first? Thank you, Mr. Chairman. You know, I appreciate the previous comments by the Senate ranking member, and I appreciate the bipartisan support that this bill has in public hearing testimony that what we heard and that's here. But I also think, you know, I've been here for 6 years now, and it's a lot easier to sit here in a room and recognize the issues and criticize things. We all think, and I think every correction officer in the state probably wants our correction facilities to be better for the people that they serve. As we talked about earlier on a public hearing day, I mean, I've toured the correctional facilities more than once, and in a lot of ways, the corrections officers seem to be the biggest advocates for the incarcerated people that they serve. And I think that, you know, there is, and we talk about this in education, we can talk about it in law enforcement, we could talk about in a lot of places. You could sit and say, well, the kids in the state enough of them aren't reading at grade level. That may be true. It may be easy to sit here and say, well, people aren't doing their job right. We need to be better. But we also have to provide, as the COs came here and asked us for, the necessary support for them and make sure they have enough people to facilitate all these things. And perhaps in this particular piece of legislation, there's definitely things I think are probably pretty good. But I just think that we need to sometimes be a little bit realistic, and we can't sit here and demoralize an entire group of people in the state of Connecticut that are doing probably one of the most difficult jobs that we ask anybody in this state to do. I'm not saying that there aren't bad corrections officers, there's bad everything, there's bad legislators, there's bad cops, there's bad teachers, there's bad everything, but I think on the whole, the department and the members of the department want to serve their people well. So I just want to say that. Thank you, Mr. Chairman.
Thank you, Representative. Representative Fishbein.
Thank you, Mr. Chairman. It's a very serious topic that we're taking up today. Before I get to the meat of this seriousness, I just want to mention, I heard troubling a few times. Senator Kissel was talking. Just wanted to inform the committee and the general public that that's our drinking word usually in the House chamber, because I use troubling a lot, and every time I say troubling, they're supposed to drink. Anyway, that being said, we'll bring it back to the serious. Anytime the government decides to take someone into their care, even if it's their own fault, the care is being forced upon them by the system. We have a duty. One of the most horrifying news events that I get, like in the middle of the night last night when I'm listening to the radio and I hear that another person died at Osborne, it sort of shakes you to the core. Why is a question that I haven't heard the answer to. But certainly the bill that's before us tries to advance, to do things actually the corrections should be doing themselves. It's fortunate when the legislature recognizes there's a problem that we have to step in. But that's what we're doing. That being said, there are portions of this bill that I still think needs work. I don't want my no vote to indicate my lack of sympathy for the underlying intent of the bill. It is certainly not that. Up here, I've been, I think, an active advocate in this area. I've had family members that have been incarcerated for a couple decades. And I've shared those stories. We got to get it right. When it's going to happen, I've been up here a while. And we ring our bells and we shake our whatever we're shaking. saying get it right, and the powers that be aren't listening. Not the powers that be up here I talked about yesterday. We have a new corrections commissioner. Hopefully things will get better. We shouldn't have to do this bill. So I look forward to working on it, as it is a House bill, and look forward to good things happening. So thank you, Mr. Chairman.
Thank
Oh,
you.
wait, hold on. I did have an oral amendment, sorry. I'm gonna make a amendment that in line 188, between overruled and by, that we insert the clause in the whole. The intent of that particular provision has to do with a matter being before the court and when the Department of Corrections would be required to pay for that proceeding as drafted now. If it's a partial win for the challenger, Department of Corrections would have to pay for that. I think that fundamentally we should be saying that if it's a whole win, therefore adding the clause in the whole would meet that intent. So moved.
Is there a second?
Second.
Seconded by Representative Dubisky. Discussion? Representative Stafford.
I'll accept the amendment as friendly, Mr. Chair.
Thank you. Further discussion on the amendment? If not, can I try your minds? All in favor? Say aye.
Aye.
Opposed? Ayes have it. The amendment attaches to the bill. Further discussion on the bill? I just want to say, before we vote, that I hear what some folks have said and think about the discussion around this and the bill. I don't think any position around this issue is easy to take. I don't think it's easy to sit in these positions and be one of the people who are talking, because you also sit in a position where people, at least I know I do, are approaching you about loved ones who are in the system. And I'm chair of this committee that has oversight over the Department of Corrections, and I have struggled to get answers for those family members. That is not easy. A couple of days ago, the ombudsperson was here, and the conversation between he and I was about the fact that as we were sitting here, trying to get medical care for someone who's in the system. That's the ombudsperson and the Senate chair of the committee that have oversight. Can you imagine what the families are going through? Because we have power, right, if you will, and we can't get answers. So this is not just about the people in the system. It's also about the people who love those people and the people attached to them. It's about a lot more people than we generally think about. And it's not about corrections officers. Quite frankly, on this issue, I don't care whether they're good or bad. That doesn't matter. What it's about is they're people, and I recognize when someone dies, that's something that gets a headline and all of that. But when someone is in our system and we aren't being responsible, and day to day they're miserable, we are breaking that human being. And so I'm never shocked, unfortunately, when I hear of a death, because I know what we have done that breaks these people. And that doesn't necessarily implicate the work of people in the system. It's the way it's functioned. There are plenty of people who are trying to figure out how we fix this system. I will say this, and I don't always say this, I'm glad to see that the commissioner is in the room, because that doesn't always happen either. It shows a level of concern that I don't know that we've always seen. And so I don't think this is about whether people are good or bad. This is about whether we are going to put our bodies to the grindstone, do the work, figure it out, and make the prisons a safer place for the people who we incarcerate so that they can come out as whole people. With that, Madam Administrator, would you call the roll?
Roll call vote on House Bill 5567 to JFS it to the floor with LCO 3553 and Amendment A. Winfield.
In the affirmative.
Staffstrom. Yes. Flexer. Gadkar Wilcox. Fazino.
Fazino votes yes.
Kissel.
Yes.
Fishbein.
No.
Blumenthal.
Yes.
Brown. Cabrera. Callahan.
No.
Chickarella. DiCaprio.
DiCaprio, yes.
Dillon. Delaney.
Delaney, yes.
Representative Dillon, I think you're on mute.
Yes.
Thank you. Doucette.
Yes.
Dubitsky. Dubitsky.
No.
Elliott. Gaston. Gilchrist.
Gilchrist votes yes.
Godfrey. Howard.
No.
Jacobson.
Jacobson, yes.
Jacobson.
Jacobson was a yes.
Thank you. Johnson.
Yes.
Khan. Lamarck Newer.
Yes.
Lesser. Senator Lesser. Marr.
Mar, yes.
Miller. O'Day.
O'Day votes no.
Osborne.
Osborne votes yes.
Havelock Tomato.
Havelock Tomato votes yes.
Perillo. Quinn.
Yes.
Rahman. Roberts. Bertigliano. Sims.
Sims in the affirmative.
Beach.
No.
Walker. Wilson.
Thank you, Madam Administrator. We'll now go to number 9 on our agenda. House Bill number 5043. There is a JFS LCO 3605. It is an act prohibiting the manufacture and sales of convertible pistols. Moved by Representative Stastrom. Second by Representative Godfrey. Discussion, Representative Stastrom.
Thank you, Mr. Chair. Mr. Chair, the JFS language here attempts to do two things. First, machine guns are illegal in the state of Connecticut. Yet certain manufacturers of pistols and other firearms are circumventing that prohibition by selling into Connecticut products that can readily be converted into a machine gun. The bill attempts to stop that by asking those manufacturers to change their model, which they have done elsewhere, including the testimony we heard in a version of the gun they sell in Europe, and to sell only those products into Connecticut moving forward. The second thing the JFS language attempts to do is to strengthen our ghost gun law. In Connecticut, you're required to undergo a background check and to prove you are eligible to own a firearm in order to get one. We are seeing too often, continuing to see too often, folks are able to circumvent that requirement by buying pieces of the firearm and putting them together without being serialized, and those firearms are being used to commit crimes in our state, being purchased by individuals who are not otherwise eligible to purchase a gun, and ghost guns continue to be one of the leading causes of illegal firearms that show up on our state's urban cities. Connecticut has had a dramatic drop in our violent crime rate over the last 10 to 15 years. We have cut our violent crime rate essentially in half in that period of time and become one of the safest states in the country. In many respects, I would argue that that is related to the work this committee has done on criminal justice reform, but also on tightening our gun laws by banning certain types of large capacity firearms and also by requiring background checks in order to purchase a gun. This bill attempts to close two of those loopholes and continue to make Connecticut a safer state. I ask for support from my colleagues.
Thank you, Representative Stastrom. Representative Fishbaum.
Yeah, I'll be brief. Shall not be infringed still appears in the U.S. Constitution. It appears that a lot of the illegal activity that is addressed or attempted to be addressed by this bill is, as I said, already illegal activity. So facilitation doesn't necessarily mean culpability. You know, I own firearms that are capable of being converted. All of my semi-automatic long guns are capable of being converted. None of them have been converted into machine guns. And to point the finger at individuals that lawfully own firearms that are possibly able of conversion, I don't think is a proper public policy that we should be setting through this bill or any other bill. So I do intend to vote no. Thank you, Mr. Chairman.
Thank you, Representative. Further comment or question? Representative Dubitsky.
Thank you, Mr. Chairman. I think it's maybe a little presumptuous to pat ourselves on the back for the decrease in crime. Virtually every state in the nation has had a major decrease in crime over the last few years, and most of them, you do not need any type of permit to carry a firearm on your person in public. And there aren't these types of ridiculous bans on all sorts of commonly used firearms. This bill is unconstitutional. A Glock is the most commonly used and possessed handgun in the state and in the nation for self-defense and other lawful purposes. And I look forward to seeing this overturned in the courts. Thank you, Mr. Chairman.
Thank you, Representative. Further comment or question from members of the committee? Further comment or question from Representative Godfrey?
Thank you, Mr. Chairman. No, I've been working passionately on this issue of gun responsibility for 38 years. And Representative Staffstrom, it's more than the last 10 or 15 years that we've seen a decrease in gun violence, gun crimes. My only continuing concern, which we can't deal with is the use of firearms for suicides. That's another topic, obviously, altogether. And it's interesting, we did major bills, major gun responsibility bills after Sandy Hook. In 1994, I was part of an effort that banned the civilian ownership of military-style assault weapons. And that did get taken to the Connecticut Supreme Court. Interestingly, the Connecticut Constitution has a higher protection. It says any citizen can own a firearm in his or her own defense. Two interesting things: only citizens, non-citizens are not covered. And in the court case that went to the Connecticut Supreme Court, they upheld the assault weapon ban by saying that yes, individuals do have a right stronger than the U.S. Constitution to own firearms in their own defense, but it is the power of the legislature to decide what the firearms for use in defense is. And this goes quite a long way to doing that. I'm very happy to support this, getting this moving along, because let me tell you, since 1989, these reasonable requirements for the ownership of firearms under the Connecticut Constitution have worked. And so I thank you for bringing this forward. Thank you, Mr. Chairman.
Thank you, Representative. Further comment or question from members of the committee? Further comment or question? Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Bill 5043 to JFS it to the floor with LCO 3605. Winfield.
Winfield, in the affirmative.
Staffstrom.
Yes.
Flexer. Yes. Gadkar Wilcox. Fazino.
Fazino votes yes.
Kissel.
No.
Fishbein.
No.
Blumenthal.
Yes.
Brown. Cabrera. Callahan.
No.
Ciccarella. No. DiCaprio.
Caprio, no.
Delaney.
Delaney, yes.
Dillon. Doucette.
Yes.
Dubitsky.
No.
Elliott. Gaston. Gilchrist.
Gilchrist votes yes.
Godfrey. Howard.
No.
Jacobson.
Jacobson, yes.
Johnson.
Yes.
Khan. Lamarck Muir.
Lester, yes.
Thank you. Lamarck Muir.
Yes.
Marr.
Mar, yes.
Miller. O'Day. Osborne. Pavlik D'Amato.
Pavlik D'Amato votes no.
Day votes no, sorry.
Thank you. Perillo. Quinn.
Yes.
Rahman. Roberts.
Yes.
Rutigliano. Sims.
Sims in the affirmative.
Veach.
No.
Walker. Wilson.
Thank you, Madam Administrator. Okay, now we'll go to number 11, House Bill number 5311, an act concerning the non-issuance of a standing criminal protective order in the case of family violence. Is there a motion?
So moved.
Second.
Second.
Moved by Senator Kissel, seconded by Representative Fishbein. Discussion. Seeing none, Madam Administrator. Wait, what? What? Oh, that's right. Representative Fishbein.
Yes, Mr. Chairman. I move that we move item number 11, HB 5311, an act concerning the non-issuance of standing criminal protective order in a case of family violence crime, to the consent calendar.
Thank you, Representative Fishbein. Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, this item will be placed on consent. Number 12, House Bill number 5428, an act concerning the powers of and duties of the Office of the Inspector General. Is there a motion? It's a JF, yes. Is there a motion? Moved by Representative Stafford, seconded by Senator Kissel. Is there discussion? Representative Howard.
Thank you, Mr. Chairman. I'm looking in line 75 and 76, where we're taking out OIG and putting in the law enforcement agency. This is regarding, at the conclusion of the IG's investigation, a report that he, because it's a he now, will file with the Chief State's Attorney shall contain the following things. And under current law, any recommended future action to be taken by that office. Now, I've read the Chief State's Attorney's testimony, and it seems to suggest that that was a drafting area, and he notes that the IG should have the power to make recommendations to law enforcement agencies, which I don't think he currently has, but, and that right now he's making recommendations to himself, but I don't think that that's not my read of it. Under statute, the OIG operates independently, but effectively as a deputy chief state's attorney. So the law, as drafted, requires him to file the report with the chief state's attorney, and then, which would also recommendations that's going to be happening within his own office to keep the chief state's attorney aware. My read of the OIG language when it was drafted, and certainly I would defer this to two people here who had significant impact on that, but was that the Inspector General's office was designed to be independent of police departments to conduct specific investigations, generally around deadly use of force, force resulting in death, in custody deaths, and we added since then to a lack of time of notification. But this seems to go so far as to say that the OIG is now going to have at least, I'm not going to say oversight because it's recommendations, right? And I'm clear about that. But in this state, we have police departments that are overseen by boards of police commissioners, or in some cases mayors, depending on how each municipality is set up. Every law enforcement agency in the state has to have at a minimum accreditation from POST, which is really the oversight, and also will be the oversight law enforcement agency, as well as the the officers themselves. So, if anything, to me, if we're going to take OIG out there, the recommendations should really go, I think, to post, because I think we're going down a road here of putting the OIG in charge of law enforcement agencies in the state. It doesn't say that. I understand that. But I also know that when recommendations come from certain offices in this state, we do this, again, in another committee, but we do this in education. Well, it's a recommendation from SDE. Well, every Board of Education is going to follow it. No one's going to buck the recommendation of SDE. No one's going to buck the recommendation of the OIG. So, we have 169 municipalities. We have 90, 8, something like that, police departments that are all very different. And I think the chief law enforcement agency or agent in each particular municipality and their oversight and the oversight of post is sufficient in reviewing the reports from the OIG, who I should note, neither the current OIG nor the previous OIG has ever been a police officer. I think the police chiefs in this state, or the colonel, the state police, et cetera, and again, the oversight of civilian review boards and police commissions, et cetera, are sufficient to review the report and make their own recommendations. And perhaps if the chief state's attorney wants to read the report and make recommendations, I think that's well within his power currently. So I object to this section, and for that reason, I'll be a no. Thank you.
Thank you. Representative Stafford.
Thank you, Mr. Chair. Mr. Chair, let me just give an example of where I think this will work. And actually, this is a case from just the last week or two in my home city, Bridgeport. The Inspector General's office did an investigation into a use of deadly force incident in Bridgeport. The outcome of that report was that the use of deadly force in that case was justified. But during the course of their investigation into that instance, the Inspector General sort of raised some questions as to why it was that the first ambulance who showed up on scene was used to transport one of the officers who was suffering from shortness of breath to the hospital, as opposed to transporting the person who had been shot and was bleeding out in the street to the hospital. I think the intent of this language is for the Inspector General to say, although I found the officer in question for the Bridgeport Police Department's actions justified in using deadly force, City of Bridgeport, figure out a triage policy for when the first ambulance shows up. Why are we transporting the officer who had hypertension as opposed to the individual who's bleeding in the street? And so I think what this is not for the Inspector General to go looking for work or to be recommending policy broadly to every department in the state in every instance. But when they're doing a deep dive into a particular instance and they find deficiencies in department process or protocol, to be able to call that out as part of their report so that those can get corrected and a similar instance doesn't happen again. I think that's what the intent of this language is designed to address. Thank you, Mr. Chair.
Thank you, Representative Howard.
Thank you. And I appreciate the House chairs, and I'm not going to sit up here and disparage anybody's police department. I'm going to try to be careful about that. But my point is, and I would agree with the chairman. I think the chairman's insinuating that was probably not the best decision that the Bridgeport Police Department made in that particular case. If that's the insinuation, I would agree. But it highlights my point, right? So we're now, but I think we can all agree that that's probably not the way to do things. But if there's a police department in the state of Connecticut that needs an outside person to tell them that, I think that police department in that city needs to take a look at it. That's my point. And I think that what this does, and what I just heard was exactly that. We're expanding the IG's authority to say, look, all right, there was justifiable, this is a justifiable or unjustifiable use of force, but I also think all these other things were done wrong. And that sort of, look, and if that's what we want to do, is say, hey, the OIG investigates everything police do wrong in the state, okay, let's do it. We better put a few more people in that office, right? Because there's allegations of police misconduct every single day. Many of them are unfounded, but they happen. So that outlines my exact concern. I think that when things go wrong in law enforcement agencies, and they do, that the municipality addresses them. And if that's not happening throughout the state, maybe we need to have a discussion about expansion of the OIG's office. If it's not happening in one or two particular municipalities, I think maybe those municipalities need to clean their own house. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, Madam Administrator, please call the roll.
Roll call vote on House Bill 5428 to JF it to the floor. Winfield,
Winfield in the affirmative.
Staffstrom,
Yes.
Flexer,
Yes.
Gadkar Wilcox, Fazino,
Vizino votes yes.
Kissel,
Yes.
Fishbein,
Yes.
Blumenthal, Brown, Cabrera, Callahan,
No.
Chicarella,
Yes.
DiCaprio,
Caprio, yes.
Delaney, Dillon, Doucette,
Yes.
Dubitsky,
Yes.
Elliott, Gaston, Gilchrist,
Gilchrist votes yes.
Godfrey, Howard,
No.
Jacobson,
Jacobson, yes.
Johnson,
Yes.
Khan, Lamarck Muir,
Yes.
Lesser, Marr,
Mar, yes.
Miller, O'Day,
Day votes no.
Osborne, Palactomato, Perillo, Palactomato,
Pavlik votes yes.
thank you. Quinn,
Yes.
Rahman,
Yes.
Roberts,
Yes.
Bertigliano, Sims,
Sims in the affirmative.
Veach,
No.
Walker, Wilson,
Thank you. Thank you, Madam Administrator. We will now move on to item number 13, House Bill number 5429. It's a JF. It's an act concerning enticement of a juvenile to commit a criminal act. Is there a motion?
So moved.
Second.
Moved by Representative Fishbein and seconded by Senator Kissel. Is there discussion? Is there discussion on this bill? It's I'm going to vote against this bill. I think that there are plenty of circumstances that feel right here, but I think there are other circumstances that, to me, don't feel as right as I think folks might think so. I can imagine groups of folks who we might not think are congregating together, and let's say there's a 22-year-old and a 17-year-old in this group, and they move together, and a 22-year-old says something that encourages, as the bill language suggests, that they do something they're not supposed to do. Does it seem like they went seeking that young person? Does it seem like they're doing some of what I've heard in these conversations that would make this feel like the right thing to do? I think there are ways in which, depending on where you are and how relationships form, you're doing something that I don't imagine was exactly what the proponents of this bill were looking to do. I think I get what they're trying to do. I just don't think that this bill quite approaches it in the way that they believe. And so, for that reason, I will be opposed to this bill. Further, Representative Fishbein.
Thank you, Mr. Chairman. So we passed a bill a few years ago based upon the concern, legitimate concern, that adults were enticing juveniles to, for instance, steal cars. And as a result of that, we put in law that if anybody's 23 or older and they were found in the act of doing that, we created a crime. At that point, I wanted 18 and older. Those are adults. You know, just the other day, I read an article about a stolen car. There's 4 individuals in the car. 13, 14, 15, and 19 years old. 19-year-old was sitting in the back seat. They'd stolen the car. 13-year-old was operating. Children naturally look up to people that are older than they are. We hear about, you know, lack of after-school programs. These kids don't have anything to do, yada, yada. All this bill does is it shifts the age from 23 down to 21. Still doesn't get me to the 18. So I understand the opposition, but I'm really concerned we've got kids dying on our streets, stolen cars. Why they're doing it? When I was a kid, never even thought of stealing a car. I can't even tell you the risky behavior that, the extreme of the risky behavior that I had considered when I was at that age. Nowhere near shooting someone, as I spoke about before, stealing a car, just for the fun of it, joyriding. We should not be allowing those things to happen, or we're not in control of whether or not they happen, but we certainly should. We're certainly in charge of trying to prevent them from happening. And I'm sick of reading the stories of adults, people over the age of 18, along with very young children in stolen cars. I support this bill. Thank you, Mr. Chairman.
Thank you. Representative Stafford.
Thank you, Mr. Chair. Mr. Chair, I'm going to, I guess maybe regrettably, I'm going to join you in voting against this bill. I supported the version of this bill that passed a couple years ago when we set the age of 23, and we said that an individual who's over the age of 23 but entices a kid under the age of 18 to commit a crime, that, you know, in addition to sort of the other impairing the morals of a minor or other charges that might be out there, that we would make an explicit charge on the books. I supported that legislation. What I didn't hear at the public hearing on this current bill is whether anyone has been arrested under that law that we passed a few years ago, whether there's anyone who maybe could have or should have been charged under that bill that was 21 or 22 years old and wasn't. In fact, I just double-checked. We didn't receive any testimony at all in favor of this bill. Not something that's been asked for. I think the law we put in place a couple years ago went far enough, and there's really not a reason to change it at this point, so I'm going to oppose the bill.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman, for the second time. You know, it's interesting. I don't want to get into a match here, but it's interesting when we actually give credence to written testimony and we don't. You know, in 2023, I think 4,500 people in our state said, don't pass the new assault weapons ban. They submitted all of this written testimony, but we didn't care about it. Passed it anyway. But now I'm hearing, well, you know, there wasn't this reflection from the testimony. Nobody's been arrested. Nobody's been arrested because the age is too high. Most 23-year-olds have a job. When we move it down, you're more apt to actually stop the bad act. So, thank you, Mr. Chairman.
Thank you, Representative. I think you actually have somewhat of a point that we should think about in terms of testimony here. But let me say this. What's in front of us is not just about cars. What's in front of us is about any criminal act. That's important to remember. And how networks of young people, and I include people who are 21 and 22 years old in that, more and more every day, by the way, how those networks are formed, again, depends on where you are. And I don't think I did not think the intention was because you happen to be next to someone who's younger, who could be not 14. We like to make these age gaps as large as we possibly can, and so we use the extreme ends to talk about it. But someone who maybe is 17, who's part of your network of people who you happen to talk to encourage, entice, whatever, whichever one of those descriptors under the bill, that we have this apply to you. I didn't think that's what we wanted to do, and I understand that some people want to get to that 18 that they wanted. I wanted to be at 26. We kind of struggle to meet in the middle, if you will. And I don't want to get down to 18. I don't want to be at 21. I don't want to be any lower than we currently are, because I think we have struck the right balance if we're going to do this. So I would encourage folks to think long and hard about the implications of this, not just in terms of cars, but in terms of anything that possibly falls under it. Because whether people have been arrested for this or not, they can be, and that is something we should be circumspect about. All right. Madam Administrator, please call the roll. What? Oh, Rep. O'Day.
I don't want to speak, Mr. Chair. I'm sorry to speak after you. I tried to put it up sooner, but all I would say is, look, if my son is convincing, my 21-year-old or is convincing a 20-year-old or 19-year-old to do something that's against the law, I want him arrested. And it's a life lesson. And depending on the arrest, you could get AR. But I just agree with the good ranking member's comments. And while I see where I think the writing is on the wall, if you will, I would encourage my colleagues to vote yes. Thank you, Mr. Chair.
Thank you, Representative. Further comment or question? Further comment or question? If not, Madam Administrator, please call the roll.
Roll call vote on House Bill 5429 to JF it to the floor. Winfield.
Winfield in the negative.
Staffstrom. Flexer. Gadkar Wilcox. Fazino.
Zeno votes yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown. Cabrera. Callahan.
Yes.
Ciccarella. DiCaprio.
DiCaprio, yes.
Delaney.
Delaney, no.
Dillon. Doucette.
Yes.
Dubitsky.
Yes.
Elliott. Gaston. Gilchrist.
Gilchrist votes no.
Godfrey. Howard.
Yes.
Jacobson.
Jacobson, no.
Johnson. Khan. Lamarck Muir.
No.
Lesser. Marr.
Senator Marr votes no.
Miller. O'Day.
O'Day votes yes.
Osborne. Pavlock D'Amato.
Pavlock D'Amato votes yes.
Perillo. Quinn.
Yes.
Rahman.
No.
Roberts.
Roberts is a no.
Thank you. Bertigliano. Sims.
Sims is a no.
Beach.
Yes.
Walker. Wilson.
Thank you, Madam Administrator. Okay, number 14, House Bill number 5437, an act concerning the approval process for proposed budgets and special assessments in common interest community. Sorry about that. 15. Gotta keep your notes together, and after a while, a lot of notes all over the place. 15, House Bill number 5490, an act concerning requirements for sober living homes operating in the state. It's a JF.
So moved.
Second.
Moved by Senator Kissel, seconded by Representative Stastrom. Is there discussion? Is there discussion? If not,
Mr. Chairman,
go ahead.
thank you, Mr. Chairman. I move that we move item number 15, HB 5490, an act concerning requirements for sober living homes operating in the state, to consent calendar.
Thank you, Representative. Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, this item will be placed on consent. Number, 16, an act concerning various criminal proposals. It is a JF. Is there a motion?
So moved. Second.
Moved by Representative Stastrom, seconded by Representative Fishbine. Is there discussion? Is there discussion? Seeing none, Representative Fishbine.
Mr. Chairman, I make a motion that we move item number 16, HB 5563, an act concerning various criminal law proposals, to the consent calendar.
Is there objection to placing this item on consent? Is there objection to placing this item on consent? Seeing none, this item will be placed on consent. Madam Administrator, when you are ready, would you read the items on the consent calendar? And when that is completed, please call the roll.
The consent calendar consisting of Senate Bill 259 with LCO 3508, I should say JFS to the floor with LCO 3508. Senate Bill 400, JFS to the floor with LCO 3542 and Amendment A. Senate Bill 502, JF to the floor. House Bill 5311, JF to the floor. House Bill 5490, JF to the floor. And House Bill 5563, JF to the floor. Winfield.
Winfield, in the affirmative.
Stafstrom.
Yes.
Flexer. Yes. Gadkar Wilcox. Fazino.
Fazino votes yes.
Kissel.
Yes.
Fishbein.
Yes.
Blumenthal. Brown. Cabrera. Callahan.
Yes.
Chicarella. DiCaprio.
Yes.
Delaney.
Delaney votes yes.
Dillon. Doucette.
Yes.
Dubitsky.
Yes.
Elliott. Gaston. Gilchrist.
Gilchrist votes yes.
Godfrey. Howard. Jacobson.
Jacobson, yes.
Johnson. Khan. Lamarck Muir.
Yes.
Lesser.
14.
Marr.
Mar votes yes.
Miller. O'Day.
A votes yes.
Pavlik D'Amato.
We did.
Osborne.
I think.
Perillo. Quinn. Brahman.
Yes.
Roberts. Retigliano. Sims.
Sims, yes.
Veach.
Yes.
Walker. Wilson. Pavlik D'Amato.
Thank you, Madam Administrator, and thank you to
About
the
my-
members of the committee. The votes will be held open until 3 o'clock for folks to get their votes in. Also happy to report, we got through obviously a lot of business yesterday and a lot of business today, so we will not be in on Friday. We will be back on Monday for our JF deadline day to wrap up the rest of our committee's work. So I know the House and Senate are in session. We'll see you all tomorrow or Thursday, but the committee will be back next Monday. Have a good weekend, everybody.
Madam Clerk, did I miss any votes?
Travis, I think she's doing in-person ones first.
Okay, thanks, Jay.
Hi, Representative Sims. Can you hear me okay?
I can hear you.
Okay, excellent. All right, how would you like to vote on? Just make sure. That means you want one, but maybe, I think you're all set.
Oh, great.
Yeah, you're all set.
Thanks so much. Have a great day.
Thank you, you too.
Alrighty.
Representative Gilchrist,
Yes, hi.
how are you?
Good, how are you? I think I got them all, but I too was just checking.
Actually, no, you know what? Number 8, Senate Bill 509.
Okay, let me just quickly. I vote yes.
Okay, and just 1 second. Maybe that's it. Yeah, that's it. You're all set.
Okay, thanks. Have a good one.
Thank you, you too. Representative Dillon? Representative Pizino? Actually, no.
I'm glad that you are.
Hey, KB.
How's it going? All right, can we start at the top, number 4? Senate Bill 476, how do you want to vote?
Pizino votes yes.
All right, number 5, which is 484.
Pizino votes yes.
You're all set. We've got everything else. We're good.
Everything else good?
Yep,
All right, thank you, KB.
thank you. 1 second, Representative.
Madam Administrator?
Is my audio that messed up?
Oh, Representative, can you hear me? I can hear you now.
Did I miss any?
You did, yes. How would you like to vote on the consent calendar?
Yes,
Okay, for Senate Bill 476, which is number 4, how would you like to vote?
yes,
For number 5, how would you like to vote?
yes,
For number 7, 503.
yes,
Number 8, 509.
yes,
Number 9.
yes,
Number 10.
yes.
Number 12.
Yes. Actually, I was there for some of those. It must be my audio.
Yeah, we were
Okay.
having some technical issues today.
I am,
Um,
yeah.
Number, so 5429, which is number 13, sorry.
No. 5429, no.
Okay. And then 5567, which is number, oh, I got you for that one, number 17. I've got you. All right, so you're all set.
Thank you, and thank you, Representative Delaney.
Ladies
I
first.
think-
Representative, give me just 1 second.
Yep, I think Rep DiCaprio might have been here before me. Were you Rep DiCaprio?
I'm not even sure, but I'm not in a hurry, so go ahead.
Okay. I'll wait till the Madam Administrator's good.
Hi, Representative Delaney. Can you hear me okay?
Yes, ma'am, Madam Administrator.
Well, let me just double check your votes for you real quick. I need you for number 12, 5428.
Yes.
Okay. Number 17. All right, you're all set.
Yes, ma'am. Thank you.
Take care. Representative
too.
DiCaprio.
Okay,
Representative DiCaprio, let me just look real quick. And number 4.
number 4, no.
Okay. Number 5.
Number 5 is yes.
You're all set. That's everything.
All right, thank you now.
You're welcome. Senator, just give me one quick second. Senator Guy Wilcox, how are you?
Hi, good. How are you? I'm actually driving right now, so can I?
You could, yeah.
You would see me and I can turn it off. Okay, great.
100%. Yep, do your thing. Consent,
Okay.
how do you want to vote?
Consent, yes.
Okay. Senate bill, for House Bill 5043, which is the governor's bill, the manufacture and sale of convertible pistols.
Yes.
For 5428, which is the Inspector General, powers and duties of the Office of the Inspector General.
Yes.
For House Bill 5429, the enticement of a juvenile to commit a criminal act. The chairs both voted no, if it matters.
Yeah. Yeah, I'll vote no on that.
Okay, and then the last item, 5567, which is healthcare in the Department of Correction Facilities.
Yeah, that's a yes. Actually,
Okay.
on that last bill, how many the juvenile bill? How
Yep.
many is that already passed? Like, how many votes are there for yes and no?
I haven't counted them yet. Do you want me to count really quick?
Yeah, I'll just vote yes on them. They're just part of my district. I'll vote yes on that one.
Okay, I'll change it.
Sorry. Yeah, thank you.
Don't, please. Yeah, no, you're all set.
Thank you so much.
You got it. Drive safe.
All right.
Representative Brown?
Oh, let me just lower my hand. Thank you.
Hi. How would you like to vote on the consent calendar?
Yes.
All right, first number 4, how would you like to vote?
And that concerning visitations, yes.
For number 5.
That concerning distracted driving, yes.
Number 7.
Concerning sentencing, approach, and provisions for offenses committed with such an agent. Yes.
Number 8.
Yes.
Number 9.
Yes.
Number 10.
Sorry, trafficking. Which one is the one you said the chairs voted no?
Number 13.
Okay, I'm a yes on 10.
Okay. Number 12.
And that concerning the powers and duties of the office, yes.
Number 13.
I'm going to vote no.
Okay, and number 17.
And that concerning healthcare, yes.
Okay, excellent. You're all set. Thank you so much.
Thank you so much.
Representative Pablo.
I just want to check to make sure I
Got all my votes in.
Yep, consent calendar, how do you want to vote?
Yes.
Okay. One second. That was it. Yep, you're all set.
Thank you.
Thank you so much. Representative Osborne?
Hello.
Hi, Senator. How do you want to vote on the consent calendar?
Yes.
Let's see. Number 7, 503.
I think I'm a yes. Let me just double check that.
That's the 26 years.
Yeah, I'll do that. I'm a yes.
Okay, and then number 12, 5428, which is the Inspector General bill.
I'm a yes.
5429, number 13. Enticement of a juvenile to commit a criminal act.
I'm a yes.
All right, you're all set.
Great, thank you.
Thank you.
Hello?
Hi, Representative, can you hear me?
Whoops, sorry, 1 second.
Can you hear me okay? Representative Osborne?
Hi.
Hey, how do you like to vote on the consent calendar?
Yes.
Um, number 7? 503?
503, yes.
509?
Vote with the chair.
5043?
That's which one?
The governor's bill, the gun bill?
The governor's bill. Sorry, I don't have it right in front of me.
You have to, yeah, I'm gonna have to
Yes.
close the votes.
Governor's bill, yes.
Okay, and I think we're all set.